Judge Moore is the current judge executive of Boone County. In our state, that's like the CEO of the county, like the county exec that they have in Maryland. Gary was first elected in 1998. In his time as a public servant, he's achieved much success on behalf of the people of Boone County through the application of consistent conservative policies. Judge Moore was raised in Pendleton County, where his father served as sheriff. Years of watching his father enforce the law and serve the people of his county instilled in Gary a commitment to public service and to community involvement. In addition to serving as the Boone County judge, he is the current president of the National Association of Regional Councils and serves in the leadership of the National Association of Counties. Judge Moore is here today to discuss the possibility that EPA may lower the national ambient air quality standards for ground level ozone. The National Association of Manufacturers issued a report stating that this regulation could be the costliest in U.S. history. This regulation would have a serious detrimental effect on jobs and electricity prices, and it could have the most devastating impact yet on Kentucky coal jobs. For these reasons, I'm proud to support my colleague, Senator Thune, in his efforts to stop this regulation by co-sponsoring the Clean Air Strong Economies Act. Judge Moore is uniquely qualified to speak on these matters given his leadership roles in both the National Association of Regional Councils and the National Association of Counties. He has a broad perspective on how this proposed rule would affect not just Boone County, but counties across the nation, rural, suburban, and urban. He'll be able to give a real-world perspective on what this proposed rule will mean to folks across the country who have to deal with the consequences. I'm pleased that my friend Judge Moore is here today to share his timely thoughts on this rule. And Mr. Chairman, I really appreciate the opportunity to come by and say a few words about my friend of long standing. I'm sure he'll make a positive contribution to your session today. Thanks.
I'm sure he will. And thank you very much, Senator McConnell. Mr. Moore?
Thank you, Chairman Inhofe and Ranking Member Boxer and all the members of this committee for the opportunity to testify on the impacts of more stringent ozone standards. I would also like to thank Leader McConnell. What a pleasant surprise. I was not expecting that. I am Gary Moore, the elected Judge Executive of Boone County, Kentucky, and here today representing the National Association of Regional Councils, NARC, and the National Association of Counties, NACo. Boone County is a suburban county in the Cincinnati metropolitan region. Throughout my region, I hear concerns about the impact of tighter ozone standards and what they would have on local governments and the economy. Similar concerns have been echoed nationally by regions and counties of all sizes. My region is currently classified in marginal non-attainment, but we would be in full non-attainment and face additional requirements under the proposed rule. Non-attainment designations impact the economic vitality of local governments, regions, and the nation. Areas across the nation face significant challenges under the current ozone standard. NARC and NACo, along with the U.S. Conference of Mayors and the National League of Cities, have requested that EPA fully implement the current ozone standard before issuing a new, more stringent standard. Today, I will discuss several on-the-ground impacts of more stringent ozone standards on regions and counties nationwide. First, local and regional governments play a significant role in protecting local air resources, ensuring a strong transportation system, and strengthening the local economic development efforts. Counties and local governments own a large portion of the nation's public road system. My county alone owns more than 400 public road miles. Many transportation projects would have to be reconsidered if the ozone standard were tightened. Additionally, areas designated as non-attainment can have a more difficult time in attracting and keeping industries due to the concerns that air permits and other approvals will be too expensive and even impossible to obtain. Second, a more stringent ozone standard would create unfunded mandates for state and local governments. EPA estimates that hundreds of counties would be impacted by the new ozone standard, A more stringent standard would be especially difficult for rural counties and small metropolitan areas, many of which have not previously been subject to non-attainment designations. Very limited federal funding is available to help these regions and counties comply with air quality standards. Additionally, the federal government can withhold federal highway funds for projects and plans in non-attainment areas, which would negatively impact job creation and economic development for these impacted regions. In 2008, EPA issued the existing 75 parts per billion ozone standard. In 2010, a more stringent standard was proposed, but EPA later withdrew it over concerns about resulting regulatory burdens and uncertainty. During this period, however, implementation of the 2008 standard was effectively halted. That process was recently restarted, and in February of this year, just a few months ago, my county received the implementation guidelines for the 2008 standard. Now here we are again discussing a new standard before we know what the current standard is, whether the current standard is working. This process has created confusion in regions and counties and about where they stand under the current standard, which is crucial to gauging the effects of an even more stringent standard. And due to 2014 court decisions, 2 separate ozone standards must be met as part of the transportation conformity process. A stricter ozone standard will only complicate matters further. In conclusion, the health and well-being of our residents is a top priority for regions and counties. We urge that EPA fully implement the current ozone standard before issuing a new, more stringent standard. We look forward to working with members of this committee and the EPA to craft policies and protect public health without inhibiting the economic vitality of our communities. Thank you again for the opportunity, and I'm pleased to address any questions that you might have.
Thank you, Mr. Moore, for the excellent statement. We'll recognize you now, Mr. McKee. Use your microphone. There we go.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, I am Michael McKee, and I serve as the chairman of the Uintah County Commission, located within the Uintah Basin in eastern Utah. I am honored to testify before the committee today to discuss the issues that we face in controlling ozone levels in the Uintah Basin, especially the unique occurrence of high winter ozone levels. Only 2 places in the nation experience high levels of winter ozone, the upper Green River Basin in Wyoming and the Uintah Basin in Utah. High winter ozone levels are a result of a complex mix of geography, weather, emission conditions. Primarily, winter ozone levels rise when snow cover and multi-day temperature inversions occur. An inversion occurs when high-level warmer air traps low-level cold air inside the basin. Snow reflects the sunlight back up to the cloud cover, and this becomes the perfect mix to allow pollutants to build up and to react to produce ozone. In the absence of these conditions, exceedance of EPA's ozone standards have not been observed. Although it is clear that our oil and gas industry contributes to ozone precursors through the release of NOx, VOCs, and formaldehydes, those same releases do not create high levels of ozone absent precise weather conditions. The county, the state of Utah, the Ute tribe, and industry have spent several years and millions of dollars to study, monitor, and model winter ozone. After all of this work, what we know for sure is that more years of research and monitoring is necessary to ensure the investments we make are effective and that we have a precise model in order to formulate appropriate controls. We are currently under the threat of non-attainment under current EPA ozone standards. However, the state, the EPA, nor the county understand what measures would be effective to reduce elevated winter ozone. Even if the EPA were to force the Uintah Basin into non-attainment, absent additional years of scientific monitoring and modeling, a state implementation plan would unlikely be effective, yet would devastate our economy by implementing a regulatory scheme at great cost to industry with few results. The proposed lowering of the ground level ozone standards would, of course, make our situation impossible to avoid non-attainment status, yet would do very little to improve our air quality. The Clean Air Act simply does not contemplate the multifaceted nature of winter ozone, nor does it provide the necessary tools to deal with the issue. Uintah County wants to improve our air quality. That is not a debate. Our oil and gas industry is willing to make major investments to reduce emissions, but will only do so if these investments are recognized and true credit provided by EPA. In the case in the Uintah Basin, we need more scientific resources dedicated toward the problem and flexibility to implement regulatory actions to determine the most effective controls. The oil and gas industry is responsible for 60% of our economy and 50% of our jobs. We need this industry to stay in the basin to feed our economy and provide the resources to tackle our ozone problems. Under non-attainment, the industry and their investments will simply relocate to other areas, if not to other countries. Mitigating winter ozone requires new authorities and opportunities for collaboration between state, tribal, and local governments. A lower ozone standard does not improve our air quality. It simply ties our hands and prevents Uintah County, and I would say areas from the west where we have high elevations, opportunities to find these creative solutions. I would ask the committee to explore new authorities and to look to successful efforts that have actually improved air quality. I would draw the committee's attention to the Early Action Compact process that EPA implemented in the early 2000s and was very successful, but litigation forced the agency to withdraw the program. The Early Action Program allowed several communities to comply with ozone standards in a very short time. The program allowed communities to enter into agreements with the EPA to implement action in a creative fashion that were effective, and the majority of the communities in the program were able to lower ozone levels to within federal standards. The program required the achievement of milestones, reporting to the EPA, completion of emissions, inventories, and modeling and control strategy. Flexibility is a key component to allow communities to implement solutions to air quality issues that are unique to their area. We believe that an authority similar to the Early Action Program with provisions that contemplate the complexity of a winter ozone is an appropriate mechanism for communities to improve air quality without destroying their economy. We all want to improve our air quality. A lower ozone standard does not achieve that goal. It actually makes it more difficult. We oppose increasing ozone restrictions and standards and request the committee to explore new tools in our efforts to improve our air quality, and we look forward to working with the committee to that end. I thank you for the opportunity to testify today, and thank you for this opportunity, and we'll be happy to answer any questions or to provide any additional information. Thank you.
Thank you, Mr. McKee.